All right, so good evening. Thanks to those who are taking the time to listen in. I appreciate it. Welcome to our workshop on May It Please the Court. This workshop is a new one that's focused on exploring the interaction between the U.S. Supreme Court and federal, state, and or local policy and political institutions, actors, and behaviors. This Zoom workshop is held live on Tuesdays from 8 to 8:30 in my Zoom room, so you can join if you'd like. Obviously, you can watch the recording as well. Our schedule for this fall is the following. So we started a few weeks ago with an overview of the federal judiciary, and then the following week we looked at the U.S. Supreme Court, and then we started listening to our first case, which is Tennessee versus Mississippi, and we're gonna continue hearing that oral argument that was started. So let me go ahead and jump us to that case. It's our first one, and we're interested in this case, Mississippi versus Tennessee, which is it's a case about groundwater use. And so last week we heard the first 15 minutes or so. Today we'll listen to the next 30 minutes or so, and then next week we'll listen to the last 15 minutes. So let me go ahead and open up the case on Oye, which is the website that has the recording. And recall that the petitioner, just the person who asked the Supreme Court to listen to the case, was the state of Mississippi. The respondent is the state of Tennessee. And the two questions that they're asking the court to answer is, first, does Mississippi have sole sovereign authority over and control of groundwater naturally stored within its borders? And then the second question is Mississippi entitled to damages, injunctive, and other equitable relief for the groundwater taken by Tennessee? So we're going to go ahead and listen to the oral argument, and we're going to jump to minute 17 because that's where we're at with that. And let me just jump us to 17. So there might be some things, if you're listening just to this one, that might be off. So you're going to have to go back and listen to the first 15 minutes. But in either case, I think you'll be good to go. All right.
Is the case here from Your Honor's example and from all the court's equitable apportionment cases.
So what I have the same kind of question. My understanding, and it's very elementary. I mean, I think water falls from the sky. Some of it's evaporated back. Others of it goes to oceans or lakes or streams. And a huge amount goes underwater, underground. It's groundwater. And it runs all over the place. That's why I like the wild horses. My idea of that groundwater is it's going all over the place. So what's the standard? Are there any cases? What's the standard when one state takes some of that running around groundwater that another state says, oh, no, you should have stayed here? It sounds to me, San Francisco has beautiful fog. Suppose somebody came by in an airplane and took some of that beautiful fog and flew it to Colorado, which has its own beautiful air. And somebody took it and flew it to Massachusetts or some other place. I mean, you understand how I'm suddenly seeing this? And I'm totally at sea. It's that the water runs around. And whose water is it? I don't know. So you have a lot to explain to me, unfortunately, and I will forgive you if you don't.
Well, Justice Breyer, I would say this. We're not claiming here that Mississippi owns the water in a sense of absolute title to the water. What we're talking about is the right to exercise control over the resource while it is within the sovereign territory and the borders of Mississippi. And Mississippi is not trying to prevent the water from flowing naturally or to go across the border or prevent the wild horses and the Chief Justice's hypothetical from going across the border. What we're saying is Tennessee does not have a right to exercise any control over them over control over the groundwater while it is within Mississippi. And what we're proposing is that states can withdraw groundwater from within as long as the physical effects, and this is something that's measurable and predictable, as I said, as long as the physical effects of that pumping does not encroach and affect the water and control the water outside in a sister state.
You're saying that the question is whether there's an extraterritorial action, but there has not been a trespass, there has not been pumping on Mississippi's land. what there has been is actions on Tennessee's land that have a measurable and predictable effect. That is often true when it comes to water, that one can take action in one state and have effects in another state. I mean, all of our cases in this area are premised on that. So why is it any more true in this case than in any other that there's extraterritorial action as opposed to extraterritorial effects?
Your Honor, because I would say that the intent of pumping is to move water and to exercise control over the groundwater in this case. And so I come back to the fact that it's measurable and predictable because that's the area over which states know they're going to be impacting and having a direct effect on the groundwater. And, you know, what Tennessee and defendants seem to want to say is, well, if there was a pipe that crossed the border and that made a physical intrusion of space, that Mississippi would win, and this case would be different. When a pipe doesn't actually do anything to water, it's the pumping that controls the water and causes the water to move from one place to another. And so to say that, well, you need to have a pipe or some sort of physical intrusion of space for this case and this exercise of control over the water to be actionable, we think would elevate form over substance because they don't need a pipe to exercise control over this groundwater.
Mr. Coghlan? I think what you're asking, or what she's asking you and pointing out, is that it wouldn't work this way if we were talking about water that was above ground. So what is your argument, and this is kind of what Justice Kagan asked you at the beginning, what is your argument for treating the groundwater differently? I mean, how much of it depends on your assertion that, well, it travels interstate but very slowly. It can take centuries to move from Mississippi into Tennessee. I mean, is it the speed at which the water moves that matters here? And if so, when is it so fast that actually it falls into the above ground kind of category?
Well, Your Honor, our view is that this principle would apply equally to groundwater, to surface water, to other types of resources. And we think that's what the Court recognized in Tarrant when it recognized this concept when dealing with an interstate surface river that had already had the remedy of apportionment applied, and recognizing that there was a different type of injury because in that case Texas was seeking to divert water and exercise control over it while it was within Oklahoma's sovereign territory. So I would posit that it does not matter that the water here is groundwater in the subsurface. The principle should apply equally, and we think the Court has found it to apply equally with surface water in Tarrant.
Mr. Coghlan?
Go ahead, Justice
Kavanaugh. The amicus brief of 8 states says that your position would, quote, inject dangerous uncertainty into established systems of natural resource management and undermine an established process to resolve disputes over a natural resource, end quote. So I just wanted to get your response to those states, which seem to suggest that your position would cause a lot of problems in how to manage these resources.
Well, Justice Kavanaugh, the state's amicus is premised on the notion that there is no known duty, and we would posit there is a known duty here. The Court has recognized it in Tarrant. It's that states can only exercise control, sovereign control over a resource within their own borders. So I think what we're asking to do is for the Court to just simply extend the principles recognized in Tarrant to the which are known duties to the case here. And I think I would respond to the Western states by saying what would happen if Tennessee wins. And I think the danger there is what we're already seeing here. We have both Mississippi and Tennessee pumping on each side of the border, trying to have a tug-of-war over this groundwater at issue, unnaturally draining the aquifer and damaging it when if based on the nature of groundwater, if both states pumped away from the border, neither state would have any impact whatsoever on the groundwater within the neighboring state. And I think that's unique about groundwater. But Tennessee could have gotten all the groundwater and pumped as much groundwater as it wanted and had zero effect on the groundwater in Mississippi if the cones of depression were not crossing the border. And so this is an area where it's distinct from surface water, because there isn't this natural leveling out of water when you take it out. There's only a limited area of effect when you're pumping in groundwater, outside of which there's no impact whatsoever on the rest of the aquifer. And I think that's a reason why conceptually equitable apportionment may not make sense to apply to groundwater, because it's not about the amount of groundwater coming out. It's purely about where that groundwater is coming from. But to answer your question directly, Justice Kavanaugh, we do not believe that there would be the detrimental effects that the Western states complain of.
Counsel, I just have one additional question. If you prevail, then presumably Tennessee could bring a counterclaim against you in those situations where your wells take water from Tennessee, right?
That is true, Your Honor. But
okay, then if they do, presumably the normal thing would be they take whatever Tennessee owes you and whatever you owe Tennessee and set it off against the other, and that's what would happen, right?
It could, Your Honor. I think that it would be a motivating factor for states to come and negotiate interstate compacts.
So if it could, that starts to sound a lot like equitable apportionment. How's it different at the end of the day?
Well, in the sense that it would motivate states to come and negotiate, we think it would be similar to equitable apportionment in that respect.
Thank you. Justice Thomas?
I have no further.
Justice Breyer? Justice Kagan? Justice
I do have one quick question, just to follow up on Justice Sotomayor's line of questioning to you, counsel. Suppose you fail to prevail here today. I'm wondering what we do next. The special master recommended that we grant leave to amend to add an equitable apportionment claim, but we don't actually have a motion for leave to amend before us, and we have a standard that has to be met, among other things, whether it's a logical outgrowth of the existing litigation, timeliness, as Justice Sotomayor alluded to. And I'm just wondering what you would have the court do should you fail to prevail.
We'd ask the court to grant us a leave to amend, and of course the court could.
Have you moved? Have you sought to meet the standards? I haven't seen that in the papers before us.
We have not yet, Justice Gorsuch.
So, again, what would you have this court's judgment line look like should you fail to prevail? We wouldn't grant leave to amend because there's no motion pending before us. Do we just say, as Justice Sotomayor said, nothing?
Justice Gorsuch, we think the court could grant leave to amend, but certainly reflect the principles you just mentioned, that if Mississippi does not behave timely or does not file a proper motion, that the court could obviously deny that.
So give you a certain number of days in which to present the court with a proper motion. Is that the suggestion?
I wouldn't put a specific number, and obviously.
Of course not. No one wants a deadline, but should give you an opportunity within a reasonable period of time, and we might set a deadline for a motion. Is that your suggestion?
We would. I think the court certainly could do that, and whatever number the court would feel would be reasonable, we would act within that period.
Thank you very much, counsel.
Justice Kavanaugh?
Just picking up on that, isn't your position that you want to preserve the right to seek equitable apportionment into the future, even if you don't seek it now? Or am I misunderstanding that?
I think it's both, Justice Kavanaugh. We would like the opportunity to replead in this manner, but also because equitable apportionment is a prospective remedy only, we would want the opportunity to pursue that in the future in a new action if needed.
Thank you.
Justice Barrett?
None.
Okay, thank you, counsel.
So I just want to pause for a moment to highlight that was the counsel for the state of Mississippi. And now the counsel for the state of Tennessee is going to come before the court. Okay.
Mr. Frederick?
Thank you, Mr. Chief Justice, and may it please the Court. Tennessee has lawfully pumped groundwater out of the Middle Claiborne Aquifer on its side of the border for more than 130 years. The special master correctly recommended dismissal of Mississippi's complaint, but erred in suggesting that Mississippi be freely granted leave to amend. First, the equitable apportionment doctrine provides the exclusive remedy for complaints about the usage of water that flows from one state into another, and the actions in one state affect interstate water flow. Mississippi's claim for more than $600 million in damages, therefore, must be dismissed. Mississippi's principal argument in response is that the aquifer water flows slowly. But this Court has never conditioned the application of the equitable apportionment doctrine on water velocity. Here, even Mississippi's expert acknowledged that in pre-development conditions, more than 37 million gallons of water per day flowed out of Mississippi and into adjoining states. Second, the master did not consider how this case would fundamentally change if Mississippi were freely allowed to amend to plead an equitable apportionment action at this stage after disavowing an apportionment claim for the last decade. Nor did the master consider that Mississippi can show no injury at all from Tennessee's water withdrawals. The undisputed facts are the aquifer's water volume in the greater Memphis and northern Mississippi area has changed very little in the past 100 years. The aquifer is fully saturated and in a state of equilibrium, and Mississippi has increased its own pumping dramatically and can extract all the water it needs. Mr. Chief Justice, I welcome the Court's questions.
Mr. Frederick, counsel for Mississippi says that if you simply moved your pumps away from the border, all would be well. What do you make of that?
Well, two things. There was testimony on this at the trial. Dr. Spruill was asked that question and said that Memphis could engage in a massive relocation, and then Mississippi's other expert, Mr. Wiley, said that it would have no appreciable effect on the cone of depression. Dr. Spruill, on cross-examination, conceded that Mississippi's own pumps are closer to the border than those in Tennessee, and when Dr. Waldron, our expert, testified, he said that that pumping was causing a reversal in the change in the water flow and that Mississippi was in fact intercepting, that was his words, water that would have flowed from Mississippi to Tennessee in its natural state.
You oppose amending the complaint here to include apportionment, equitable apportionment. What does it stop Mississippi from simply filing a new motion in this case and starting all over?
Nothing would stop it, but Mississippi would have to meet the standards for a material change in circumstances that would warrant this Court's consideration of an equitable apportionment claim. In the case of Colorado versus Kansas, decided in the early 1940s, this Court said that the standard was a material change in circumstances. That, of course, was the long-running dispute over the Arkansas River. And what the Court said was that if that material change in circumstances has not occurred, then denial of a motion for leave to file a complaint is the appropriate disposition.
Thank you.
Mr. Frederick, you claim that the equitable apportionment is the exclusive remedy. The amici law professors say it shouldn't be, that a nuisance action could also be appropriate. If all they wanted was to stop you from drawing water because the way you're drawing it harmed the aquifers, which is, I think, what I heard them say earlier, why wouldn't a nuisance action be appropriate?
A nuisance action would be appropriate if there was damage to the water or if there was some issue of subsidence or other water quality. I think this Court's case in City of Milwaukee is representative of a cross-boundary tort. But what they are complaining about is our usage of the water that flows in interstate
So it's a question of how they pleaded.
I think that's correct. And in the nuisance context, the law professors don't say exactly how you would administer a nuisance claim under what they are talking about. And I would point out that there was evidence at the trial about the absence of subsidence or any degradation in water quality. We presented that in our defendant's proposed findings of fact numbers 246 and 47 on page 126A.
One last question. What does a material change mean to you? What would qualify?
I think what would qualify is if Mississippi was able to plead plausibly and with the suggestion that clear and convincing evidence would follow, that it was unable to extract water, that it had to engage in significantly increased costs in order to pump, that it suffered a degradation in water quality, or that there was evidence of subsidence in the aquifer as a result of pumping, those would be of the type that you would measure their significance based on the classic standard.
Given the way this has been litigated, those issues have not actually been decided by anyone.
They haven't been decided.
So why should we even say don't amend until there's a material change? Because we don't even know what the baseline is right now.
Well, what you would say is that, and I think to your earlier question to my friend, I think you would say nothing. Where the special master erred was in suggesting that there be a free motion to amend without actually following through the necessary steps, a motion satisfying of the standard for a material change in circumstances. And you do have cases on this, Your Honor, Nebraska versus Wyoming, which looked at the question of what constitutes a fundamentally different change of character of the claim is directly on point, as is the Colorado versus Kansas case. So you do have standards. It would be Mississippi's burden, of course, to prove that since 2010, when this court denied Mississippi's complaint in the alternative for an equitable apportionment, that circumstances had changed sufficiently to warrant allowing it to go forward.
Mr. Frederick, suppose that Mississippi had an entirely intrastate lake that was near the Mississippi-Tennessee border, but was all the borders of this lake were in Mississippi. And suppose that there was some newfangled technological way of Tennessee helping itself to the waters of that lake. Would that be an equitable apportionment claim, or in that case would Mississippi have a different kind of action?
I think it would have a different kind of action. The equitable apportionment doctrine has applied to interstate bodies of water in which there is flow, there's natural flow. And under your hypothetical, Justice Kagan, there would be no interstate character to the water.
Is there such a thing as when you're dealing with groundwater, looking at groundwater and saying that it moves so slowly, with the consequence of transferring so little water between these states, that we should treat it as my hypothetical rather than treat it in the same way as, say, an interstate river?
There was no evidence at the trial, the 5-day trial, about that, although there was a lot of questioning about that concept. And all of the hydrologists acknowledged a couple of key facts for the court. One is there is no physical barrier between the water in the ground under Tennessee and under Mississippi. There is no distinction in the subsoil surface, the sands and the composition. It is one continuous hydrological unit. That was acknowledged by all 5 hydrologists who testified. And so what you would be looking at there, I think, is a situation that would be quite different than the aquifer that we have before us here. Now, on the volume question, Justice Kagan,
maybe that would be true. You started by saying, oh, look, this is like 37 million, what was it, 37?
37 million gallons per day.
Right. And you suggested that that's a relevant fact, such that if there weren't 37 million, if there were 37,000, or if there were 37, we should maybe have a different way of analyzing this question. Is that right?
I don't think so, because in the interstate lake hypothetical that Justice Thomas, I believe, posed, you'd still have the same kind of phenomenon. Water in its natural state is always going to be moving. Water molecules will be moving. Now, how quickly they move ought to be irrelevant to the application of the equitable apportionment doctrine for a couple of reasons. Legally, the Court has never said that, and in the Oregon versus Washington case, where it looked at whether or not the anadromous fish, Idaho case, the anadromous fish, those fish were out at the ocean for years before they came back to spawn. And the Court has also considered situations where rivers have run dry for long stretches of time before there's any water flow. It nonetheless has held that the equitable apportionment doctrine applies. But on the volume point, Justice Kagan, I think it's important to take into account the size, the sheer size of this aquifer. not only does it encompass it lies underneath parts of 8 different states, but the thickness of the aquifer is huge. In parts of it, it's as much as 500 feet. In parts under Tennessee, it goes to 1,100 feet. And so 1 inch of movement per day, which is what the testimony was at trial, can translate into tens of millions of gallons of water per day. And, of course, if you were to annualize that, you'd be able to cover the entire District of Columbia in more than a foot of water by the amount that is moving 1 inch at a time out of this aquifer.
Mr. Frederick, our doctrine of equitable apportionment arises in the area of moving water, of rivers, and you're asking to extend it to groundwater, and you've made a very strong argument for why that might be sound. I'm wondering what the limiting principle is, however, and what we're buying here. Is every aquifer in the country that might have some interstate effect now going to be part of this court's original jurisdiction? Is Justice Breyer's fog now part of the court's original jurisdiction? Is the Chief Justice's herd of wild burros, who may or may not be a nuisance, part of this court's original jurisdiction now?
Well, what the court has held is that the equitable apportionment doctrine applies to natural resources, principally water, and in the one case of the fish, to the public trust doctrine.
But so far it has been about moving water and the fish. You're right, I forgot about the fish. Okay, but that's part of the moving water of the salmon in the river. And this is an extension, and I'm just analytically, what are the outer bounds of it? You can sell me on how it's not a big deal. Fine, I got it. But what are the outer bounds of this principle? Where does it end?
I think the outer bounds are where this court recognizes the public trust doctrine to apply. In those resources that are outside the public trust doctrine, the court has not applied the equitable apportionment principle. And so in those resources, air is one of them. Justice Holmes recognized that in the old Illinois Central case over a century ago.
Right.
So to Justice Breyer, if
so
there were such a claim,
the wildfires in California affecting Colorado, the boroughs, I'm not aware of any in Mississippi, but there might be some. All of that's now part of the court's original jurisdiction.
Well, I would say that, of course, the burden on the complaining state has to be a significant injury of substantial magnitude. That has been the court standard for over a century from Kansas versus Colorado. And if the boroughs or the fog created a significant injury of substantial magnitude, I think it would be appropriate for the court to exercise its jurisdiction. Sitting here today, I have a hard time seeing that in the real world, but I think that what the court could say is that you have extended groundwater in certain respects to equitable apportionment cases when there has been substantial pumping of groundwater that has affected surface flows. You did that in the Oregon versus Washington case back in the 1930s, where there were 300 pumps of water on the Oregon side of the boundary, and the court said that Washington nonetheless could show no injury to its own irrigators because there was subsurface flow that was occurring. You've held that in other cases involving compacts where you've enforced compact decrease for surface flows, notwithstanding the fact that there have been substantial water pumping going on either side of the state. And so I think that it's not that far of an extension to say that where Mississippi has uniquely pleaded a claim about an aquifer, that all the evidence showed at trial was connected to surface streams. And here the Wolf River, itself an interstate river, flows directly into the Middle Claiborne Aquifer at a recharge zone in the eastern part of the area that we're talking about.
So I'm going to go ahead and pause this there at the 43:37 mark. What we'll do next week is we'll pick up where we left off to hear the remainder of this argument. Just a couple of thoughts, and then I'll stop the recording, and then we can get to a brief discussion. The first one is you've heard a lot of different terms, and three that I want to draw out are the idea of injury. The second is the equitable apportionment principle or doctrine, and then the second is the public trust doctrine. Those are things that we can examine in more detail in the future, but I just want to draw those out because they're, in my mind, pivotal parts of this conversation that's happening in the case. The second thing is keeping in mind that each of the justices has an opportunity to ask questions. This is actually a newer setup that Chief Justice Roberts has instituted, basically making sure everyone has an opportunity to engage in the dialogue, as opposed to allowing members who like to speak up or like to talk out of turn or like to dominate the conversation doing so. The last thing is noting that there's a lot of complexity with hearing any Supreme Court case, but my hope is that, as you heard from the prior week and this week, and then we'll hear in the following week, is that this complexity is really interesting, right? It's like a fascinating part of the aspect of American jurisprudence or lawmaking, our interpretations of the Constitution, our understanding of how things are supposed to work and how they might not work. So these questions that are being asked by the justice to the lawyers for both the petitioner and the respondent, the dialogue that's happening, the analogies that are being used, as you saw me laughing when they talk about the wild burros that was referenced in the first 15 minutes or so of this case. It's just fascinating to hear these conversations. So hopefully you find them informative. With that, we'll go ahead and stop the recording, have a brief discussion, and look forward to seeing you at the next one. So take care.